Welcome, welcome. I'm back for Tina Talks. I've been in lockdown with all of you and I hope you've all been safe and well. I am so excited to be back in the office. I am working bubble days in a very COVID secure environment. I hope those that have returned to work are enjoying the atmosphere that you can only really get at work, in my view, and you've settled back in to your commute. So now I'm back. What am I going to talk about today? I'm talking about furlough and I'm talking a little bit about redundancy. But before I start yapping away, remember everyone, I do have an email address, tinatalks@righthassle.co.uk. If you've got any questions, fire them away. I am back. Okay, so the furlough scheme came back with a vengeance to help us all through the difficult months caused by coronavirus. The current scheme, it's available until the 30th of September 2021. It has numerous similarities to the previous scheme that was first introduced in March 2020. There is a taping down of the scheme. Up until 1st July 2021, employers, you can claim 80% of an employee's salary up to a cap of 2,500. So don't forget that there is a cap in place. You must pay pension contributions and NI. So from 1st of July, the scheme reduces and therefore what you can claim from the government tapers down. However, you're still responsible for ensuring that the employee receives 80% of their salary. However, so from 1st July, you can claim 70% of an employer's salary, but it is subject to a cap of £2,187.50. Again, you must pay NI and pension contributions. So in August and September 2021, you can claim 60%, and that's up to a maximum of £1,875. You must top it up by 20% and you remain responsible for NI and pension contributions. And then 30 September, that's it. The scheme is closed unless we hear any different. Employers, you will need to start making some decisions and I would urge you to make those decisions way before the scheme ends. The reason why I'm asking you to consider now is because from 1st December 2020, the government said, employers, you cannot claim contractual or statutory notice whilst employees are on furlough leave. So employees, you have to give consideration as to what you are planning on doing when the scheme ends. And you might be considering returning all staff to work. You might be considering implementing a redundancy process. And I'm going to move on and talk about the redundancy process very briefly. But it's really important that if you're watching this today and you have staff on furlough leave, have a think now while you've got some time as to what you're going to do when the scheme ends on the 30th of September. Okay, so when the scheme ends on the 30th of September 2021, employers, in reality, employees should be able to return back to work and resume their usual contractual salary. If you are in a situation where your workload has diminished, the business is just not where it was at, and you don't have enough work for roles, or you need to restructure roles, then I would urge you to give that some consideration now. Whilst employees are on furlough leave, you can commence a redundancy process, but what you can't do, as I've said earlier, is claim contractual or statutory notice pay. Following a redundancy process is not straightforward if you are doing it by yourself. So first of all, get some advice. If you want advice from me, please contact me, but getting it right will prevent claims. It won't necessarily stop claims because employees do take decisions in relation to redundancies quite personally, but you need to make sure that you have followed the correct process. And in following the correct process, the first thing you need to do is have a legitimate business reason to place roles at risk of redundancy. You then need to consider if you are looking at unique roles or you are looking at reducing headcount amongst a number of roles, and those particular employees all do the same or like-for-like work. you need to engage in meaningful consultation. And that's a two-way dialogue. That isn't just listening to an employee ask you questions. You must engage in meaningful consultation. So that involves listening to their ideas, considering ways in which you could potentially avoid a role becoming redundant as a business, looking at if there are other roles within the organisation that you can present to employees to apply. Unfortunately, if after 2 meaningful consultations there is simply no option to retain a role, then you will be in that unfortunate position where you will have to confirm redundancy. It's really important that you obtain the correct redundancy figures and don't make those sorts of mistakes. If, for example, employees are on furlough leave and you decide to make a role redundant, then you will have to consider making payment in lieu of notice or asking the employee to return to work their notice period, because you cannot claim furlough pay whilst for contractual or statutory notice. If employees are dissatisfied with the decision to make their role redundant, then it is very likely you will receive an appeal. If after you've received an appeal, they remain dissatisfied, and obviously subject to you following a correct appeal process, you may well hear from ACAS, and that'll be giving you a hint that that employee is potentially going to bring a claim. And again, as I've said through this Tina Talks a couple of times, seeking advice on the redundancy process is key. And therefore, if you have any questions and you would like to discuss redundancy, please just contact me. I shall look forward to my next Tina Talks back on the couch. If you have any questions, please just drop me an email.